Welcome to the Explainer. If you're looking to understand exactly how the Department of Education handles administrative discipline, well, you're in the perfect place. Today, we're demystifying the entire life cycle of a DepEd case. We're going to go from the very first accusation all the way to the final appeal, and we're going to do it without drowning in a sea of legal jargon. Let's get right into it. Okay, let's dive into this. Our absolute cornerstone today is DepEd Order No. 49, Series of 2006. This is the official document, the ultimate rulebook dictating the revised rules of procedure in administrative cases. Literally every timeline, right, and rule we cover today, it comes straight from this source. Here is our chronological roadmap for today. 1. Grounds for disciplinary action. 2. Filing an administrative complaint. 3. The investigation process. 4. Preventive suspension explained. 5. Decisions and penalties. And finally, 6. The appeals process. Section 1. Grounds for disciplinary action. Identifying the misconduct. Right off the bat, under Section 58, offenses are strictly classified by severity into 3 buckets: grave, less grave, and light. And the stakes here are incredibly high. For instance, a grave offense like dishonesty or nepotism can trigger immediate dismissal, even if it's just your very first offense. Less grave offenses, like simple misconduct, might result in a suspension. Meanwhile, light offenses, something like habitual tardiness, often start with a simple reprimand. The punishment is scaled directly to the gravity of the act. Moving to Section 2, filing an administrative complaint, initiating the process. According to Sections 4 and 5, you can't just fire off an angry email or text message to start a case. It actually requires a formal, sworn, written complaint. You have to state full names, narrate the relevant facts, and attach documentary evidence and affidavits. And this brilliantly illustrates just how structured this process is. Why do they do this? To immediately weed out petty, baseless rumors and ensure total fairness from day one. 10. That's the magic number here. If a formal complaint is actually deemed sufficient, Section 8 dictates that the disciplining authority has exactly 10 days to appoint an investigator. The clock starts kicking immediately, meaning these cases don't just sit around in a filing cabinet gathering dust. Section 3. The investigation process. Finding the facts. Now, it's absolutely vital to distinguish between 2 totally distinct investigation phases. First up is the fact-finding investigation. This is an initial, often ex parte look just to see if the complaint even has merit. Only if official charges are filed does it escalate to a formal investigation, which is where the respondent actually mounts a full defense through official hearings. So, how do you jump from fact-finding to a formal charge? Well, the investigator must find a prima facie case. Stripping away the legalese from Section 9G, this simply means there's a reasonable ground to believe the respondent is probably guilty, which makes a trial-like investigation necessary. It's the exact trigger for issuing that formal charge. And boom, once that formal charge drops, we hit another highly critical deadline, 72 hours. Section 10 strictly dictates that the respondent has no less than 72 hours to submit a sworn written answer. It really forces a rapid formal response to whatever the allegations might be. But keep Section 27 in mind here. These are non-litigious proceedings. This isn't an episode of Law & Order, right? The strict technicalities of courtroom evidence, they don't strictly apply here. The ultimate goal is a speedy resolution that still carefully protects everyone's right to due process.
Section 4. Preventive suspension explained. Temporary removal.
This is a highly misunderstood concept. Under Section 16, a preventative suspension temporarily removes the respondent from their office. But listen closely. This is absolutely not a penalty yet. It's purely a protective measure. It's used to stop a respondent from, say, intimidating witnesses or shredding documents while the investigation is still ongoing. So, the crucial point is 90 days. Section 18 states a preventive suspension cannot exceed 90 days. If the case isn't decided within that 90-day window, the respondent must be automatically reinstated. Well, provided they didn't cause the delay themselves, of course. Moving on to Section 5. Decisions and penalties. The resolution. The ticking clock doesn't stop for the decision-makers either. Section 42 mandates that the disciplining authority has to render a decision within 30 days of receiving the formal investigation report. This ensures employees aren't just left dangling in prolonged, stressful uncertainty. Interestingly, under Section 59, the final penalty isn't just some rigid black and white calculation. The committee actually weighs mitigating or aggravating circumstances. For example, an employee's good faith or a really long record of service could reduce the punishment. On the flip side, taking undue advantage of an official position will absolutely tip the scales against them. Now, you might be wondering what happens if someone is guilty of multiple offenses. You don't just stack penalties like building blocks. Section 61 provides a really interesting rule. You impose the penalty of the most serious charge. That primary penalty absorbs the rest. And those lesser charges, they just become aggravating circumstances.
Finally, Section 6, the appeals process, challenging the decision.
Let's move to and see how this builds because the timeline for fighting back is remarkably tight. From the exact day an adverse decision is received, a party has exactly 15 days to file a motion for reconsideration. If that's denied, they have another strict 15-day window to elevate it to the Civil Service Commission. If you miss these non-negotiable windows, the decision is final and executory. And you can't just appeal because you're unhappy with the result. Section 48 outlines that you can only appeal if you can prove one of three things: newly discovered evidence that materially changes things, a decision unsupported by the evidence, or clear errors of law. You literally have to prove one of these three legal grounds to even be heard. Which brings us to the ultimate thesis of Section 27, and really, this entire process. DepEd Order No. 49 is a deliberate, careful balancing act. It requires taking firm control to enforce discipline, but always, and I mean always, with proper regard to the fundamental rights and due process of the parties involved. So, we've tracked the timeline from the very first offense to the final appeal. I'll leave you with this final thought. Knowing this highly structured life cycle, do you view these bureaucratic rules primarily as a rigid system of punishment, or as a vital, necessary shield designed to protect due process? Thank you so much for joining me for this explainer. See you next time.